Hi, this is Alan Gassman, and we want to welcome you to Estate Planning for 2013 Beyond the Obvious. It's already Tuesday, February 5th, 2013. It's 5:01 p.m., and I'm very pleased to be joined here by my partners, Ken Crotty and Denicolo, and our newest addition. We're so proud to have you here today, Tom Ellwanger. How are you doing, Tom?
Well, thank you. It's great to be here, Alan.
And before we begin, I want to remind everybody who's watching that Ken on February 7th at noon is going to be giving a clinic on the 50-minute guide to disaster avoidance on gift tax returns. So avoid disaster on Highway 709. That's a complimentary 50-minute webinar for advisors on gift tax returns. And we've been learning a lot about gift tax returns over the last couple of years. There's a lot to know. Also, on Monday, February 11th, that's next Monday at 5 p.m., I will be spending half an hour on what we're calling the Physician's Guide to the 2013 Tax Laws. We're going to have a lot of doctors joining us and also a lot of advisors joining us, and we welcome any questions, comments, or suggestions that you might have. And on Tuesday, February 19th, Lester Perling, a great healthcare lawyer from Broad & Cassell in Fort Lauderdale, and I are going to be talking on Florida law health traps, 4 hypotheticals and discussion of important medical structuring and regulatory issues. So please feel free to join us for any of those. Also, before I forget, you have our emails here. Mine, for example, is agassman@gassmanpa.com. My assistant, Mary Beth, is going to be monitoring these emails. So if you have any questions today, please let us know. We'll get back to you. Please excuse me for hurrying, but we promised that this would be done in 30 minutes, and we are going to be done, for the most part, in 30 minutes. And that means that we're going to go pretty quickly. We're going to skip a lot of the materials, but we included it because we thought you might want to read it on your own. And I am now on page 5. By the way, we did email the PDF to everybody. A couple of pages are a little bit different, but no substantive changes. And if you're looking at this on screen, you're fine, and if you want us to email you the updated version, we'll be glad to. But on page 5, I know everyone here understands that we now have a 20% long-term capital gains rate, a 39.6% short-term capital gains rate, that hurts, a 39.6% ordinary income rate. It's a 20% rate on C corporation dividend. I'll have to fix that. And now we have an extra 0.9% in employment taxes and a 3.8% investment income rate on the Medicare tax. So we have a lot of extra taxes now, a lot of big hit income tax issues, 43.4% income tax for our high wage earner clients. And that's really going to impact our estate planning in a lot of ways that we're going to talk about today. As you know, we've got a 2013 $5,250,000 exemption now with a 40% gift tax. Yes, I have to correct page 5, but let's go to page 6. Page 6, again, the new estate tax law. The annual gift exclusion has come up to $14,000, and it's going to go up with inflation every year. It's going to be geared to the CPI index, and it's going to go by $1,000 intervals. It'll probably be $14,000 this next year, 2014, and then it's probably going to be $15,000 the year after if we have inflation at about 2 to 2.5% as we expect. Tuition and medical direct payments are still going to stay where they were, perfectly exempt. Lifetime exemption, $5,250,000 this year. So we got a $130 million increase from last year. And those clients who think they may have an estate tax issue can start thinking about making their $130,000 gift. So you'll see that on our checklist. Estate tax exemption is united with the gift tax exemption and with the GST exemption. A 40% estate tax rate, which is not a bad thing. Now, a new chart for you to print out and use in your conference room. Please feel free to white out our firm name and put your name there. This is a protective trust logistical chart. I think just about everybody on this call knows that on the first death, you can lock up to $5,250,000. That becomes a bypass trust, a GST trust in most cases, which can benefit the spouse and then be held for children in separate trusts on the second death, all avoiding estate tax. And the big issue now is that we have this $5,250,000 exemption. How do we fill up this family trust on the first death if we don't have $5,250,000 separately for each spouse? And we're going to talk about that because it's going to take some getting used to. Now, the surviving spouse is going to have an indexed allowance. In this case, we were guessing $5,700,000, but we won't know what it's going to be. It's going to be based on the CPI. It's going to be based on the life expectancy of the surviving spouse. So a lot of clients are going to be thinking that they're not going to have an estate tax issue. The other thing that most of you are aware of is we have permanency now in portability, which means that if the first dying spouse doesn't use the full $5,250,000 or whatever they have left, whatever is not used can be used by the surviving spouse, but as we're going to explain in a little while, it is not increased with the Consumer Price Index, and it gets lost if you remarry and lose your new spouse and your new spouse doesn't have an exemption. So that portability is going to trick more people than it helps, by my estimate. The other thing we have going on is that the administration did not get everything they wanted in the estate tax cliff negotiations, and one question is whether they're going to get some of those things they wanted later. You know, there are some things that the administration wanted that they're going to continue to ask for, and of course the Republicans don't want to give anything else up. They want all spending reductions, and we think there's going to have to be some compromise on some taxes, so clients are going to understand that grats, discounts, and defective grantor trusts are all at risk. Okay, we have developed a checklist for the 2013 Estate and Entity Asset Structuring update here. And of course, number one is to get the client's information. If you don't have the client's information, you can't help them. Unfortunately, we have charts for our clients, and it's not that difficult to keep up with them. Now, I'm going to show you a real treat because we have been developing our own in-house software, and we've come along pretty far, and my partner, Ken Crotty, has spent a lot of time on this. And we just came up with a situation, and I'll just introduce this here, where you have a married couple, and they only have a $750,000 home and a $5,250,000 savings. They have $100,000 a year that they think they'll be able to put away in the future. They have a $14,000 a year gift exemption with 2 children. They think they'll use 25% on that for things that the children will spend. 75% of that will be saved for the children. They assume a 3% growth rate on their home, a 7% growth rate on their investments, minus 1.5% a year to pay taxes and advisor fees, and that the surviving spouse will live 30 years. And they would not expect to need to use a credit shelter trust because of portability, because on the first death you'd have a $10,500,000 allowance. So Ken, you want to take over here and tell us what you found using the software program?
Thanks, Ellen. What we're showing here is on these assumptions, after 30 years, the surviving spouse is actually going to pay $5.8 million worth of estate tax on the death of the surviving spouse. And what we'll show you after the webinar is done, if you're interested, just stay on the line, and we can go through a little bit of the program in a little bit greater detail to show you where we're at. But turning to the next slide, if we take the same assets and all the same assumptions and we put half of them in the bypass trust on the death of the first spouse, leaving half of them with the surviving spouse, you see after 30 years we've reduced the estate tax to $1.8 million. So the family's saving $4 million simply by putting half the assets in the bypass trust rather than relying on portability.
Right, and of course if they had put all the assets in the bypass trust, they'd have no tax. Now, when Ken runs these numbers for you, he's going to show you what would have happened to this family if their assets had increased based on the S&P 500, how it's done since 1981. $5 million in the S&P 500 in 1981 would now be worth over $100 million. So there's a big reason not to rely on portability, and we're going to talk about how to pack a credit shelter trust in a couple minutes. Also brings to mind, oh, and by the way, we would love for anyone listening to help us beta test this software. So please let us know, send an email. We're looking for beta testers. We're really enthusiastic. It's got some very neat features that we want to, if you can hang on after the 5:30 ending, Ken will show you. Now, Bob Burke's rule, for every complex situation, there's a simple answer and it's usually the wrong answer. Complex problems almost always call for complex solutions. So give us a little bit of slack here as we explain these other items. A little bit more about portability. It does not preserve GST exemption. It does not grow with the CPI. You lose it if the surviving spouse remarries somebody who doesn't have an exemption and dies before them. It's not creditor protected. It can't be leveraged with debt. So we're not big fans of portability. Now, you will hear that there are times where portability may be preferable. But even where the credit shelter trust is going to be funded primarily with an income asset like an IRA or a pension account, if that surviving spouse is going to live 15, 20, or 30 years, I think the time value of money from the estate tax threat really outweighs the income tax issue. And we are going to be running numbers, and we'll be glad to demonstrate that to you later on. If you do have to stretch a trust into a credit shelter trust, because there's going to be a lot more of that in the future, this chart should be helpful. There's not always that much difference between the client as the beneficiary of an IRA or the credit shelter trust as a beneficiary of an IRA or the children as the beneficiary of an IRA, but you can run the numbers on this, and we plan to have our software working to do that as well. Sample letter talking about portability, some sample language for the will to allow the surviving spouse to get the portability election we have here at page 17. Make sure your clients have that. And now we're on to page 18. Page 18, Chris, you want to take this over?
Of course, Alan, thanks very much. You know, in light of this new tax law changes here, we want to give clients to make sure that their revocable trusts really are structured so that they can take advantage of credit shelter trust funding and planning in light of these new laws. You know, one item to really consider is whether portability or credit shelter trust funding would be preferable. And of course, our spreadsheets would show that, and it's an analysis that we should all take as advisors. Another issue to consider is whether we want our clients to have joint trusts, our married clients to have joint trusts, where we give the first dying spouse a general power of appointment over the revocable trust in order to possibly obtain a full step-up in basis on all assets on the death of the first dying spouse. I urge you to look at private letter rulings 2002-10051 and 2001-101021, which the IRS found that this is a good technique for filling up the first dying spouse's credit by using a general power of appointment.
So let's talk about that. So if I have a married couple and they have $6 million of assets and that's all they have, but a strong income stream, and let's say those assets have a low basis, like $1 million, and one might die first, I could put that $6 million of assets into a joint trust, and then on the first death, possibly get a full step up and $5,250,000 locked away in a credit shelter trust?
Well, it's arguable, but there's certainly a position that you can take against the IRS. Of course, they're going to want.
Well, the IRS letter ruling said that said that you get the full credit.
Exactly.
But only half the step up.
Right. It is arguable based on the way the letter rulings are written, and of course, private letter rulings aren't precedent, except the taxpayer that requests the ruling himself. Other issues to think about here: whether you want to establish a promissory note between one spouse or another, just to facilitate full funding of the first dying spouse's credit on their death. Another thing that we've done in the past with some clients is given maybe a client that's more wealthy than his spouse, give a less wealthy spouse a power of appointment sufficient to fill up her credit upon her death if she dies first. And this was covered in IRS Private Letter Ruling 2004-03094.
So in other words, if I have $10 million in my trust and my wife has very little in her trust, I actually give her the power on her death to appoint up to $5,250,000 of the assets in my trust,
correct,
which she does, and she appoints it to a trust that benefits me for my lifetime.
That can work under Internal Revenue Code Section 2041 and this private letter ruling.
Wow. Well, a lot of people are going to be doing those.
And we have some sample language here on the next slide that shows this technique. You put this top language here in the wealthier spouse's living trust, and then the bottom language would go in the less wealthier spouse's last will and testament, just to facilitate this to occur and make sure we capture this credit shelter funding on the first death.
Now, those of you watching this, if you send us an email, we'll be glad to send you these letter rulings. And also, there's an excellent 2007 article by Michael Mulligan in the B&A Estate and Gift Tax Quarterly, which does a really nice job of explaining these techniques and explaining every potential risk. Because the IRS may try to change its stance on these private letter rulings, although we think that they're, pretty strong. And we're writing an article right now on this, so if anybody's interested in brainstorming with us or looking at these issues, let us know. But for the most part, if you have a married couple with assets in the $6 to $7 million range, and you can lock up $5,250,000 on the first death, probably never have to file a 706, you've got plenty of good reasons to be thinking about a joint trust.
Another great benefit of locking up the assets on the first death is getting the step up in basis. And we have here on the following slide a number of strategies that we want to consider to employ in order to get that step up in income tax basis. Some of them might include giving voting interests back to the client so that the client would have control over an entity so that valuation discounts would not be applicable. The client is not as concerned with estate tax, but maybe more concerned with capital gains and income tax down the road. The step up in basis would be desirable.
So, for example, if I put $4 million into an a limited partnership, and I've given half the voting rights to a trust for the client's children, the client owns 90%. When the client dies, there was going to be a great discount to avoid estate tax. The client may not need the discount to avoid estate tax anymore. So now we may want to shift the voting rights back to the client. So when the client dies, there's a full step up in basis for all the assets under that limited partnership. It's going to be reversing a lot of things that we did. It's very interesting. But we need to do that carefully to preserve the charging order creditor protection that would otherwise apply. So.
And another neat idea when the estate tax isn't as much of a concern as the income tax is to amend the revocable trust to provide that a committee of independent fiduciaries could have the power to give the surviving spouse a general power of appointment, which would cause a step up in basis on the assets that would otherwise not be included in the surviving spouse's estate on her death. And that's something we put in our forms since the law came out in 2010, and I think it's worthwhile just to have that in there going forward in case the surviving spouse doesn't have estate tax concerns down the road.
Right, that's really essential because I don't want a client to come to me in 20 years and say, hey, I get no step up when my grandmother dies because you didn't put a provision in that allows a special committee to give her a power of appointment. So we are putting that in all of our credit shelter trusts, and we're going to start putting them in our GST trusts as well. It's going to be essential as the capital gains tax rate is so much higher and the estate tax is so much less of a threat now.
Now, there's some other strategies that you can do to facilitate this. Some of them being the outright devise with a disclaimer to the credit shelter trust. Another strategy you can use is to have special trustees that could cause the outright disposition of assets to the spouse from the credit shelter trust. We prefer this general power of appointment committee to bestow this general power of appointment because it's more flexible. You don't really have the creditor issues that you would have during lifetime if the surviving spouse was to receive assets outright. It's just something that's very easy to draft for, and Clayton Q-tip is another strategy you can use here. In the interest of time, we'll just skip through this.
Can we go back to page 20 just a minute, though?
Sure, Alan.
Okay, this is something I think we're going to be seeing a lot of. Look at the bottom of page 20 here. Your clients have set up irrevocable trusts. They've put assets in them. Those assets have gone up in value. Your clients gave up control over these assets. Their brother-in-law is the trustee, or their CPA is the trustee, or their ex-best friend is the trustee. And they did it to avoid estate tax, and now the client may have no estate tax risk anymore. So why not reclaim this irrevocable trust? Why not go to the probate court judge and say, Judge, I gave this away because I thought I had to avoid estate tax. I don't want to take it back, but I'd like to be the trustee now. And I've also been told that if you'll give me the power to appoint how the trust assets pass on my death, that on my death, they'll get a step up in basis, which will be good for my children. So I come before you, Mr. Judge, today with my children, and they and I and a guardian ad litem appointed for my great-grandchildren are all requesting that you make me the trustee, let me invest this however I want, and let me control where it goes as long as it stays in my family line or to creditors of my estate. So I think you're going to see a lot of those as to those trusts that you're not going to just bust up. So as you review your client situations, you can think about that. Okay, I'm going to work past this list of getting stepped-up basis off of a credit shelter trust. You're going to be seeing a lot more articles on this. We wrote about this in the B&A 2011 to 2012 planning book. If you'd like to see our chapter, just let us know. By the way, the Delaware tax trap doesn't work in Florida, so skip all the articles and all the chapters that talk about the Delaware tax trap if you're in Florida. All right, page 34, and it looks like we're going to make it out of here by 5:30. Really consider the completed gift hybrid creditor protection trust. This is discussed in our September 16, 2012 Thursday report. If you're not getting our Thursday report, let us know. We'll put you on the list whether you like it or not. And what you can do now is you can establish an irrevocable trust where the grantor can replace the trustee at any time. It can be protected from the creditors of the grantor and family members, we believe. It can benefit the spouse and descendants, and under Private Letter Ruling 2009-44002, it can also benefit the grantor. Now, what we've typically done is we've provided that the grantor is not a beneficiary, but that the trust protectors, who are independent from the grantor, can add beneficiaries who are descendants of the grantor's grandparents. And only those people who have a net worth below the grantor's net worth. Because our feeling is if the grantor's net worth stays up, they won't need to be added. If the grantor's net worth comes down, they can be added. But that would be a fact of independent relevance, I think. So that way, we don't report the grantor as being a beneficiary of the trust. But the trust could loan money to the grantor. The trust could own limited partnership and LLC interests in entities that the grantor can control. So now you have a really good business reason to do an asset protection trust. And really, the main detractor from asset protection trusts being expected to work is lack of a business purpose. Well, now there's a good business purpose, and if the S&P 500 performs in the next 30 years like it did in the last 20 years, a lot of people are going to need these, so don't sell them short. And there's more data here on asset protection trusts. We don't tell clients that we're 100% sure that domestic asset protection trusts are going to work, but we have already seen a lot of creditors basically fold their tents when they see an asset protection trust formed in Alaska before the debt occurred. All right, page 41. Now every year, besides that $14,000 per year per person exclusion, we're going to have an exemption increase. It makes sense to go to the client and get them to make a $130,000 per person gift, but we have to let them know that that's going to require us to, that's going to cause us to have to file a gift tax return. So they may want, the younger clients may want to wait and do this every other year or every third year, but it is something that we want to get the clients disciplined to do. Now here's an Excel spreadsheet that we'll be glad to send you, and you can work from it. But if you have a $14,000 gift, 6% growth, take a 30% discount on valuation, so it's really $20,000. You've got an extra $6,000 gifted. So the estate tax savings from using these discount vehicles are pretty good. In just 10 years of gifting, the estate tax saving for each child is $31,000. And the next chart shows you in 20 years, the estate tax savings is $88,000 or $93,000. So it's a nice thing. If you do a $214,000 gift your first year and then $14,000 a year thereafter, there's significant savings. All right, number 7, calendar for additional gifts. We all, or many of us, made gifts where we did not use the entire $5,250,000 exemption because we used discounts, and we're going to wait and see whether we get audited and whether they try to take part of our exemption away. So set your calendar for 3 years after you file the gift tax return, because then you're going to have more exemption for sure that you're going to want to be able to use. Now, lock in your discounts now. As I said before, the Obama administration still wants to do away with discounts. So that's a good reason to take remaining LLC and limited partnership interests and sell it to a defective grant or trust on an income tax-free basis. For a 9-year note, you'd have a 2.31% rate right now. for a just under 9-year note, you'd have a 0.87% rate. So you can lock in that discount, take that 0.87%, 9% note, you're going to have a substantial impact. And of course, GRATs, Obama wants to move GRATs to being required to have a 10-year term with a 10% remainder interest. They're not going to be as good, so there's still plenty of things to do for clients who still have plenty of wealth. And as we watch the economy rejuvenate, we're going to see that happen. Number 9, we have a lot of defective grantor trusts where it's been great that the grantor could pay the income tax, but oops, 44% income tax, less concern about estate tax. Should we consider toggling that trust off now, making it a complex trust, and letting it pay income to the lower income bracket beneficiaries? Or for some larger defective grantor trusts, you could split it up into 2 defective grantor trusts and toggle one off. One would get enough income to spray the income to the beneficiaries to make up for their low brackets. Of course, you've got to take the kiddie tax into account, but toggling off the grantor trust status is going to be another choice that we're going to all be looking at. Number 11, if you have any estates going, you want to elect a November year end for 2012, and you can let that income stay in and avoid the 3.8% Medicare tax, or spray it out to beneficiaries who are not going to be subject to the 3.8% Medicare tax, and then you're going to have that estate in the 35% bracket instead of the 39.6% bracket. So if you can elect or change to a November year end for a recent estate, it probably wasn't worth dying for, but it will at least help the survivors a little bit. Number 11, do you still need all that life insurance? And we, of course, love to run our spreadsheets on life insurance. You're welcome to use these. We've got some term rates and some spreadsheets, so if you want us to send you these and you can adapt from them, please feel welcome to. Number 12, cleanup time. Now you've got the opportunity to go clean up all those messy interfamily loans, get rid of those entities you didn't need anymore, cash in that life insurance if you don't need it anymore, fund these irrevocable trusts to buy out remainder interests in other trusts, and just do what you need to do with a nice high exemption. Let your imagination run free, as long as it's all billable. All right, number 13, don't forget that now you're going to have, I think, a good chance of some really increased real estate values, a much higher capital gains rate. We're going to see more 1031 exchanges. And don't forget the Cupert. The Cupert is still going to be a very valuable planning tool. This is our Cupert spreadsheet that we're going to move into our planning software. And also, just don't forget to gift a home to a trust for the children. You know, maybe you haven't done that in the past because of exemption issues. You can gift a home to the child. They can keep the homestead exemption. They can keep the $250,000 or $500,000 sale exemption. They can be sprayed with the income when it's sold, so they better behave. And it can be a credit shelter trust that your spouse can still benefit from. So the real estate planning is going to be a really nice thing. And then number 14 and 15, because I want to follow my promise and be on time, look at your rental situations. Are you going to reduce the rent if you're causing a 3.8% rate? Are you going to have the landlord start paying a management fee to an S corporation owned by a child to kind of allow the tenant to still pay that rent, but to allow somebody else to reap the benefit? We need to look at these early in the year rather than late in the year, because we're already through January and we're already causing tax liability. And the same thing with our income tax planning. Is it better now to raise the rates, to raise the wages of what you pay your son-in-law, no matter what he's worth or she's worth, as opposed to making gifts, get a tax deduction, have them use that money to invest in a limited partnership that the client can control? It's time to really increase your pension planning, get those actuaries in, look at cash balance plans, look at defined benefit plans, make the children work, put them on the payroll more now than ever. There's just plenty of great opportunities here. So we want to thank, and finally, the charitable planning. You've got plenty of charitable planning opportunities, a much higher tax break for charity. We do have the charitable lead annuity trust example here you're welcome to see. And then I've got, just for fun, a few reasons to get your clients divorced, especially if they don't get along anyway. And then if you do 1040s, you got 2 1040s instead of just 1. So there are lots of good tax reasons and some creditor protection reasons to get divorced. But Ken, I'm going to hand this back over to you now. And before I do, I just want to thank Tom Ellwanger again for being here and helping us put these materials together. And Ken, I'm going to turn this back over to you and let you go to the software and show everybody how neat this is. I'm looking forward to seeing it.
Okay, so as we talked about earlier, this is using the example where the family has $6 million total of assets, 5.25 in investment assets, and the $750,000 home. Now, Alan had mentioned earlier about increasing this exemption rate. Hold on one second, I apologize. If we increase the interest rate, the standard compounded growth rate over the last 30 years was 10.96. So that's almost 11%. So in this example, where we didn't use a bypass trust, the surviving spouse, on the death of the surviving spouse after 30 years, you're looking at $28 million worth of estate tax. And again, if you grew it at 7%, you'd be looking at $5.8 million. So that's a big difference.
And those of you who are interested in beta testing, please note, you put your variables here, and then as you change your variables, the chart and the numbers automatically change on your screen. So you can see exactly where you want to go, and then save that image and go to a comparison image. So we really welcome your ideas, but we're really proud of what we've been able to put together here this week.
And also some other things that you can change are you can change the assumptions regarding how long the surviving spouse is going to live. So in this example, if they only live 20 years, you'd be looking at $8.9 million worth of estate tax.
If they get nasty at you, you can kill them off early.
You can also show the impact of if we make 6 annual exclusion $14,000 gifts instead of 2. You can see how much more the family's getting and how the estate tax has been reduced. But going back to our original example, and I'm going to put this back at 30 years, so we're dealing with $28 million worth of estate tax. If we go ahead and instead we fully fund the bypass trust, and it's going to take me a second to do this. So we fully fund the bypass trust with the $5,250,000, and we take the surviving spouse and we leave her with no assets, or him with no assets. You can see that based on the same assumptions, the estate tax is only $243,000. So you'd save the family over $28 million by not relying on portability in this example and fully funding the bypass trust. So as Alan mentioned, we're looking for beta testers. If you're interested in getting a copy of the program and letting us know your thoughts with it, just send us an email and we'd be happy to send it to you. Thank you very much for attending today's webinar, and we appreciate the interest and look forward to receiving the comments and suggestions from everybody on any of the slides that we presented.